Recorded live.
Hello, everybody. We're going to do a show here on rules of engagement and the indispensable parties and political question doctrine. Ladies and gentlemen, we got some very serious issues here with what's going on. And I want to try to break this thing down for you all for a better understanding, because there's a lot of questions and a lot of rabbit trails that is coming up out of this. There's a lot of different theories, but I want you to follow me, because what we're looking at is standing right there in front of us, and we're trying to look around it instead of looking at it. With recent discoveries on our shows and the recent definition of the word person being found in vital statistics under a state statute and under IRS code, that the word person is a trust and an estate. For a long period of time, people have said this, but they have never been able to back it up. Well, we have now found it. We need to address the rules of engagement of those who come after us. And there are rules on their side of the fence. But because we lack the knowledge, because we lack the understanding, and part of it is we lack finding the proper definitions to support our argument. That right there is the key thing. We have not had proper definitions in order to support, because we haven't been able to find them till recently. The simple argument of going into this court starts out with is that we need to file an enter of an appearance. And we need to make the separation between that name that is being charged, now that we can prove that it is a trust, it is an estate, it is property, and that the state is receiving federal grant money, makes them an indispensable party here to this action, because they are receiving money on behalf of that name, on behalf of that trust, on behalf of that estate, that property. We need to set the court when we walk in a position, because every single attorney that goes into a court is required to file an enter of an appearance. The judge will sit there and say, well, we'll allow you to represent yourself. He don't tell you you have to file an enter of appearance. He does not tell you to file an enter of appearance. We'll allow you to represent yourself. Us not knowing any different, we did. Therefore, because we were representing ourselves, because we did not file an enter of appearance into this court, we were not heard. This is part of the game that they play. Rules of engagement says they have to sit down and disclose the rules, and they're not doing it. It's up to us to know this stuff. It's up to us to come in and address it. One of the issues is when we are being charged is that we need to now bring claim against the prosecutor. We need to remind the court that under the theological history of justice, justice is supposed to be blind. Justice is not supposed to be the Lone Ranger with a mask with eyeballs. It is supposed to have a blindfold to where it does not distinguish color, race, creed, or who is before it, whether you're a bar member or non-bar member. That scales is for you to put your evidence on for it to balance in your favor or in the opposing side's favor. Now, what I'm going to say here tonight, some of you are not going to appreciate, but it's the truth of the matter. With what we have discovered, even a murderer and a rapist can get off because they're not charging them properly. They are not bringing in a corpus delicti. They are not bringing in a party of interest. They're bringing the state of into that courtroom. They're bringing the United States government into that courtroom. Supreme Court has ruled on corpus delicti. Supreme Court has ruled on Miranda. Supreme Court has ruled on clean hands doctrine. Supreme Court has ruled on fruit of the poison tree. These are all significant errors that's being done by prosecution. But prosecution, the judge, and even if you had a public defender, the fact that you would file an end of appearance on your part as a party of interest into this as a living man and making the distinction between that all capital name being a ward or a state or a trust. Once you make that distinction, now they're going to have to address it, which now comes into the political question side of this, of the bankruptcy. It now poses a question before them that once you start addressing the bankruptcy, once you start addressing the trust, the financial obligations that the state is receiving off this name, there's a high possibility they're not going to want to go any further with this because now it exposes and becomes a question of jurisdiction that they cannot answer because it is a legislative issue. But let's address the rules of engagement on those who are under an oath and under a contract for wages, compensations, and benefits. Those who bring charges against you cannot violate constitutional protected rights that has been laid out by Supreme Court decisions, has been laid out by legislative defining definitions of words and how they are to be interpreted. They cannot change the definition. I've had several emails from Rod under Boutier's, under Webster's Dictionary. These are the definitions. Well, that's fine, except for one problem here. Are we being charged under Boutier? Are we being charged under Webster's? Or are we being charged under state statutes and United States statutes and codes? Which argument do you want to make? You want to make the Boutier? You want to make the Webster's Dictionary argument while they're charging you under United States codes and state statutes? Or do you want to go back into their statutes and their definitions of words? Which now poses a political question. How am I defined by your legal definitions? And who created the definitions? Was it lawyers, the Bar Association? Show me the legislative law that gave the Bar Association control over the court system. That's a political question. You've got a group, a private organization, an agency that has taken over the judicial side of this thing, which is not part of the three branches of government, but a private association. Addressing the prosecutor and reminding the judge that justice is blind. She has no bar party in here, no bar brother, because they cannot be considered. If justice is blind, then the partnership between her and the prosecutor has to cease. Otherwise, the court has now become biased and prejudiced. The issue comes now, is this man, this prosecutor, this attorney, did they or did they not apply for a job in a public office under a contract for wages and compensation and benefits, and part of that contract were they not required to raise their right hand and swear that they would uphold and defend and protect the Constitution and the laws of this country. You've already got this prosecutor already in perjury. You already got him in what is known as official oppression. He's misusing that office to oppress and to overthrow the Constitution. And the moment you bring in Supreme Court cases on the Miranda, clean hands, fruit of the poison tree, corpus delicti, that sets the standard for these courts and what their rules are for engagement. The moment he bypasses them, he is now is in insurrection and rebellion, which is a felony and an act of treason under Title 18, Chapter 115. He has now put false information before this court because under his bar oath, he is required to come into this courtroom and not mislead, misrepresent, misconstrue, put false information before this court. So now, again, under a second oath to the Bar Association, as to his public office, he has now committed perjury under 1621. If you have a public defender and you bring this up, you've now got your public defender under the same charges because he has failed to put a proper defense up for you to make these issues before the judge, reminding this judge, justice is blind. Justice is to have a set of scales. Justice is not supposed to recognize bar cards. The court now is put into a political question arena about who's running this courtroom and what is running the courtroom. Because now you're showing that a private agency, non-governmental, is in total control of that courtroom. And where's the legislative authority that gave them absolute control to walk in and disregard the Constitution and disregard supreme law of the land? And the reason why I am telling you people this here tonight, ladies and gentlemen, there is so much information that's going around out here, and we're overlooking the obvious. And part of it because it's new, because we just brought this up on the show here in the last couple weeks. But I really want you to give it some serious thought about what we're talking about here. Because when the prosecutor fails to name the indispensable parties in this action, when he fails to sit here and say, Your Honor, we're going to bring in the birth name, but when we bring in the birth name, we now have to bring in the state that that birth name is registered to and the Social Security Administration and the United States of America as defendants. When he fails to bring this up, he's failing to name all parties in this. You and I are not a partnership with any of this. Even though they try to let us believe that when we're in here, well, you're in this partnership. Your name's on there, they got your name, so you're part of this. No, sir. If I was in a partnership, then I would be receiving part of this federal grant money from that the state is receiving from the federal government, and I have not received a dime. Therefore, I am not in partnership with any of this. I have not received anything on behalf of that trust. Think about what we're getting into. Think about what we're saying here, ladies and gentlemen. You're walking into a court. You file your enter of appearance. You make the distinction from the charging name as being a trust, award, government registered trade name. You bring yourself in as a real party of interest or an intervener as a living man, woman, soul. You file your enter of appearance in stating that. Now you've separated yourself from that trust. You now bring up to the judge the contract side of the public office of the prosecutor. He is under a contract for wages and compensation. He is receiving gratuities and benefits and is a partner with the government. So he is with partnership here. He's an association. You proceed to sit here and explain his violations of what he did not do. He failed to sit down and validate a corpus delicti. If they fail to give you your Miranda, you bring this up. The Supreme Court has ruled before any questions were put before me, anything was ever searched, a Miranda had to be given, and no Miranda was ever given to after it was over and done with. This now presents the fruit of the poison tree. You can't use, because Supreme Court decisions has ruled this. You bring up the clean hands doctrine. It's because this man's under a wage and contract, and he is under an oath to a public office as a flesh and blood being, he has now advocated perjury before the court. Because he has failed to identify the accused, and he has willfully failed to identify the accuser. But I want to tell you people something. You got people out here that will try to go run this. Ladies and gentlemen, get the knowledge behind you. Get the understanding behind you on this, so you could walk it right through them and explain it to them. Because you're going to have people out here who's going to try to sit down and walk in and say, well, that's the trust name, and the prosecutor lied here, and he committed perjury. And if that's going to be your statement, it is better that you keep your mouth shut. Your statement should be go in and walk him through the statutes that he violated and the doctrines that the Supreme Court has laid down on how things are supposed to operate. And get into the definitions of the words, how they are defined, and how they are being taken out of context and being misled before the court. Again, a murderer and a rapist could get off because they are not charging the individual, the human being, on our side. When we use the word individual and human being on our side, we know what we mean. On their side, when they use the word individual and human being, it has a different context of definition. Their side, it means corporation. Their side means monster and animal. Our side, when we're outside that courtroom, has an entirely different interpretation. And that right there is the key issue, interpretation. We need to start pushing this in these courts. They've only got two choices once we start pushing this. Either dismiss because of a political question, or be corrupt, at which point under 63C 2D American jurisprudence, they no longer can claim immunity because once you explain this to them, their immunity has been stripped. Their immunity is only on ignorance on their side. Willful and intentional ignorance. That's why your lawyer don't bring nothing up. These court cases, if we would start coming in and identifying the parties in this, the all-cap name as a trust, as an estate, as a corporation, as a ward, owned by the government. And then we come in and enter ourselves as a party of interest or an intervener, as a third party into this. Identify ourselves as a living soul and enter our appearance as such, as a living soul. Don't enter your appearance because that judge is going to take it. You're entering your appearance as that trust name. Enter your appearance as that living soul, as that living man, that living woman, as that party of interest. Now you've made a distinction and there's no misunderstanding. And you proceed to explain the indispensable parties under the bankruptcy of 1933. You start bringing in the Federal Reserve Act of 1913. You start bringing in the Social Security Act of 1935. You start bringing in the Alien Registration Act of 1940. And you show how all these pieces fit together and how the fraud came about of the prosecution putting before this court. You want to try to keep this judge in a neutral position. Allow them a way out. Because the lawyer is allowing a judge a way out for ignorance. The prosecutor is allowing that judge a way out for ignorance. You're going to allow this judge a way out for knowledge and understanding and explaining the fraud. And of course, you're going to address this in your paperwork as well as verbally. Ladies and gentlemen, all this other hocus pocus, abracadabra, open sesame, is what has got us in so much trouble throughout the years. If we would start going in and laying out the truth before the court and exposing the fraud before the court, they're not going to have no place to go. Those of you who knew who Wendell Millhouse was back in 1933 made a statement, by the time the people are aware of what we have done, we'll have plausible deniability. To a certain extent, the man's right. But because of the knowledge that we're now laying in here, the plausible deniability is no longer feasible. It's only deniability because we lacked certain information to walk in here with. We lacked definitions. We lacked the understanding of the bankruptcy. We lacked the definition of the Federal Reserve note. We lacked the ability of knowing about the Social Security Act and the money that was going to the state. We lacked the Alien Registration Act of 1940. The key opponents that we needed, we lacked knowledge in. We no longer lack this knowledge. This now becomes an issue that can be addressed in any courtroom hearing, from murder down to child custody and everything in between, traffic, IRS, you name it, it all now can be addressed in the same fashion because it's that birth name that's being named in that court. So even if they were to change the birth name from all capital, it's still the birth name. It doesn't matter how they spell it now, because now we understand So it doesn't matter how they spell it. It's still the birth name. Unless they bring in somebody other than the state of in that courtroom that the state is representing on behalf of somebody else. That's the proper way to do this. The state is representing on behalf of somebody else, and they have to be in that courtroom. They have to be sitting in that seat right next to the DA. This is the body. This is the corpus delicti. This is the injured party. This is what happened. This is the injuries that they received. Ladies and gentlemen, we're on a new breakthrough of going into these courts and exposing and laying everything out and exposing their fraud, which comes into the big political question before this court of them being able to handle the fraud that's being committed in that courtroom and it being exposed. When you can sit here and start pointing out and reminding that judge that justice is blind, required to be blind, required to be impartial, and you proceed to explain the violations of the attorney working for the state under his contract, under his compensation, this now comes into a civil rights violation. This now comes into official oppression violation. And there's laws on all this. There's laws on all of this. And if your public defender does not break any of these issues, he is now under official oppression. He is now under a civil rights violation. He's now violated his ethics of representing you, even though it does sit down saying in Corpus Juris Secundum, Volume 7, is that he is, nevertheless, he is allowing you to believe that he is there on your best interest. You've been lied to. That's perjury. He accepted money. Whether he is a public defender or whether he is a paid lawyer, he accepted money under a false pretense. He can be charged. He can be held accountable. But let's look at this thing from the simple side of what we're talking about here. Some of the stuff you guys are going to have to defrag your memory in order to understand the simple side of this thing of walking in and nailing them under that birth name and that we're not a party to it. There's no partnership here. That's what they want to nail us under. Well, there's a symbiotic partnership here between you and this trust name. No. If there was a partnership here, I would be receiving federal grant money on behalf of this name like any other silent partner in any other business. They get paid. You and I have not received anything. And that prosecutor and the public defender and that judge is making out as if you received benefits. And everybody's sitting here saying, well, don't accept any benefits. You have not got a single benefit from any of this. A benefit is something that they give to you free gratis. You don't have to ask for it. You don't have to go file for it. You don't have to go put your name on the list. You're not receiving benefits. Again, this goes back into this patriot stuff of, well, if you got a Federal Reserve note, that's a benefit. No. That's a means of living. Without that, you can't survive. The problem of it is, if everybody was to do what some of these people were doing, let's sit here and say, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. We got 11 people, 12 people, including myself on here. Let's sit here and say that we all create a trust. And out of these 12 people, we put one of these 12 names on that trust. So we're now free. We're now independent. Problem of it is, I now have to represent your trust, or somebody's representing my trust. Are you really out of the system? Because now I may be out on my trust, but whenever your trust gets hit, guess who has to answer for it? So are you really free and out of the system? No, you're not. It's another one of these deploys by someone who thought they had a good idea, but they didn't think it through. They only put their self out and put somebody else responsible for them. Why don't we just make the state responsible? Wouldn't it be so much easier than it is for us to try to come up with some type of trust among ourselves, is to go back in and say, excuse me, Your Honor, is it not true that my name is registered to the state? Here's a copy of the birth certificate. Is it not true that the state has received Social Security grant money? Here's the Social Security Act of 1935. Isn't it true we're required to have a birth certificate? Here's the Alien Registration Act of 1940. Isn't it true that the Federal Reserve note is an obligation of the United States? Here's the Federal Reserve Act. Isn't it true that we're under bankruptcy of 1933 and we can't have gold, and that we have been defined as enemies of the state? Here's the Bank Conservative Act. Prove it wrong. The state is responsible. The state is the receiver. The state is the trustee. The state is the registered agent. The state is the administrator. The state is the trustee. The state is the beneficiary, because they're reaping the benefits. Where do you and I play a part in this? Where do you and I get anything out of this? Where are we receiving any benefits? Where are we receiving any gratuities? This is the piece that's been missing. This is the piece that everybody's overlooked. This allows us a whole new argument walking into these courtrooms across this country. Mr. Jones, you owe child support for your son here and your daughter. Excuse me, sir. I have their birth certificates here, and they are registered to the state. And the state is receiving Social Security federal grant money on behalf of their name. Why isn't the state paying child support? Matter of fact, here's my birth certificate. I'm also registered as a trade and a trust for the state. Why ain't I being paid? You, on the other hand, sir, you're holding a public office and you are being paid. You are receiving benefits. You are receiving compensation. You are getting gratuities. You do have insurance, right? So you're receiving the benefits here. You're receiving pay here. Where am I getting anything? Think about it, ladies and gentlemen, how simple this thing is, and we've overlooked the simplicity of this. Think about how simple this is, and we've overlooked it. And a lot of it because it wasn't until we got our hands on the vital statistics that literally went back and defined the word person under birth certificate as a trust and as an estate. And in the Social Security and into the IRS, where it listed a person as a trust and an estate. These were some of the key things that we missed. Like I said, getting into the Social Security Act, that was definitely. That proves, there's the absolute proof that the state is receiving federal grant on every live birth. There's the proof. Saying it and proving it's two different things. Now we got the proof. Now we got the evidence to walk into court with. Now it's a process that you have to learn your skills to walk and talk. You now have to learn to be able to come in and defend. You now have to learn how to enter your appearance in properly to put you into a court case, and not as that birth name, but as a third party of interest, as an intervener, and pointing out to the judge the errors of the prosecution and the fact that he is trustee, because the judge is the administrator and the prosecutor is the trustee. If you get a public defender, he's now the trustee, and now he takes full liability of the indispensable parties in that courtroom, because he now assumed that position as the state and as the Social Security Agency and as the United States of America. He now assumed those positions and didn't tell you. Is the court going to be happy with you? I doubt it very much. But like anything else, we got to get the word out, and we got to start pushing and hammering. And like I have brought up before, people, well, does this apply to foreclosures? Yes. What about IRS? Yes. Any court case. Think outside of the box. This is one thing that I have told you people, and I'll tell you new people right now. The difference between me and majority of the people out here, most people look down at the desk and they look inside of a box. And that is as far as their vision goes. I, on the other hand, look up into the heavens, and I have everything before my eyes as far as I can see, out past the stars, out into the universe, into the next one over. That's the difference. I don't confine myself to looking down into a box. I look up. The arguments is not going to be that hard. It's just that you have to be able to understand your argument when you walk in there. This goes with paying taxes on your property, vehicle, taxes. We now can bring administrative charges. We now can make this an administrative issue and bring this up and start charging that live individual, that live body, and bring them before an administrative court. And if they don't want to hear it, they want to sit back and say, well, they don't work here, then we take them right into the county court and we sue them in a civil action for negligence and breach, official oppression. It isn't going to take but a couple times to go do this. They're going to start changing, because once this starts happening, the word's going to start going across the country like a wildfire. We don't need hocus pocus. We don't need abracadabra. All we have to do is walk in there with the facts, walk in there with the truth and conclusions and facts and laws. That's all we have to walk in there with. Is it going to upset them? Like I said, yes, it is. Is there a risk? Yes, there is. But what's the risk if you don't? What's the penalty if you don't? It's better to walk in and hit them with the truth. It's better to walk in and expose this than it is to walk in and keep your mouth shut because I really don't want to upset the system. The system doesn't have a problem with slapping you into debtor prison. And that's what I did here on the show earlier. The difference between prison, or are they really debtor prisons? Because debtor prisons means they're charging you because you didn't pay. There's no way to pay. There's no money. It's Federal Reserve notes. So all these prisons are debtor prisons. And they're not calling them that because if they did, it would be obvious. So the rules of engagement on their side is the very rules that we need to go back and learn and bring in and start nailing the prosecutor for perjury and insurrection and rebelling and overthrowing the government and overthrowing the Constitution, because he's not upholding your rights. Because the issue is this, ladies and gentlemen, the Supreme Court has ruled they cannot make a constitutional right a privilege. Those who hold public office swore the same oath as the prosecutor and that judge. They cannot create codes and city ordinances in violation of protected rights. If they do, that prosecutor is required to prosecute them. Think about what I'm saying. If they create laws against your protected rights, then that prosecutor has a job to prosecute them because they breached their oath. Now, I've noticed something, and I've watched Tombstone and Wyatt Earp, Kevin Costner, and Kurt Russell. They put signs up about dropping your firearms off at the sheriff department or at the marshal's office. They had city ordinances. They're not saying you can't have them. They just didn't want you wearing them in town. You could always wear them in, drop them off, and pick them up on the way back out. I've noticed that they had signs up to drop them off. The new guys were going to get drunk and they're going to have shootings. They didn't arrest them for having them. They just sit down and says, here's the sign, drop it off, and on your way out, pick it up. Ladies and gentlemen, this is very significant of what we're sitting here getting into and what we're talking. It is very significant of what we're definitely getting into and explaining to you. We have overlooked the obvious of all this. But our number one thing is we never knew how. We never knew how to come into the court. We was never told. Through me doing what I have done, we found the way in. Like I said, we got to file that end of appearance. We have to file that end of appearance in this. We got to make that separation between who we are and what we are, and who they claim we are. You have to make that distinction. So a lot of people have sit here and said, "Well, the courts are operating according. No, they're operating right." Well, yeah, they are. I don't agree with it because they're relying on our ignorance and they're taking advantage of us. And some people, well, that's your fault. No, that's not our fault. We have not been educated. We have not been trained. We have not been told. Once you are told, once it is explained to you, now if you allow it to be done to you, now it is your fault. Monday is going to be very interesting because this is going to be brought up. And it's going to be interesting to see what they do and how they handle it. But ladies and gentlemen, Galileo sit here and proved that the earth was not the center of the universe. He got punished for 20 years. 20 years later, they released him and accepted the fact that the earth was no longer the center of the universe. Just because we go in and things may happen doesn't mean that it's wrong, especially when you're sitting on all the evidence and all the documentation to prove that it's right. Galileo proved that the earth was not. We revolved around the sun. The sun didn't revolve around us. He proved it, but the church didn't want to hear it. And that's what I'm saying here. The court isn't going to want to hear this. Don't make it wrong, because the evidence is overwhelming on our side of the fence. It's one thing to sit here and talk this stuff and not put up one lick of evidence to prove my argument. I'm asking you, take my word for it. Trust me. I'm not asking you to trust me. I'm asking you to look at the evidence. I'm asking you to look at the documentation. I'm asking you to make your own conclusions and facts, to make your own decision. That's the number one thing here. We're walking in here with the proof. And if you stop and think, this is exactly what the court has tried to do, is keep this stuff out of the courtroom. Why? Why did they want to keep it out? Why don't they want this brought in? Because they know if it ever started getting brought in, it would prove the fraud. It would prove that the judicial system is corrupt and is running under RICO. And the fact that it is no longer a third branch of the government, but ran by a private association. And the problem of it is, under the political question, if you were to bring a political question, no attorney could be a party to the answer. Yes, they are barred, because a political question goes back to legislation. But rather, we've got legislators. Yes, we do. And how many of them are bar members? How many of them are lawyers? They can't answer the question. We'll go to the executive branch. How many are lawyers? And how many of them going to sit here and say, well, we got to go to our law firm? No, it's a political question. They can't answer it. Because it deals with them. They cannot answer their own question. Look up political question doctrine. Look it up. You're going to find it in the law books. You're going to find it under USC code. And it gets in, and you need to look up the case laws on this. We have now posed a federal question and a political question before this court of the bankruptcy, that if they were to answer it, it would expose, and they can't expose. If we was to sit here and bring up the political question about the name, are you not trying the birth name? Is that birth name not tied to the state to a trust which receives money? That's a political question. But if they were to say yes, think of the consequences. They would now have to sit here and explain, and now they'd have to justify why we never received anything on behalf of that trust. Let's look at what's standing before us, what we've talked about on the last several shows here, ladies and gentlemen. Let's push everything off to the side. I'm not saying erase it. I'm not saying forget it. I'm saying let's push it off to the side. And let's look at what we are bringing up here in the last several shows of the indispensable parties. The fact that we have now proven that that name is a trust and an estate. The fact that we now can prove that that name under that birth certificate, the state received federal grant money. It was given by the government. The fact that we have proven that our signatures are being sold and securitized off of, we've proven this because it says so in the congressional records of McFadden, as well as in other cases of people that we've known through the researchers for forensic auditors that's going back and showing where the bank is securitizing off your name and they're selling your name. Ladies and gentlemen, we're sitting on the absolute proof of this. You have that Credit River decision that sits here and says where Jerome Daly went after Montgomery Bank, and the banker sitting there and said, oh yes, we're not giving you any money. We are giving you a credit line off your name. And the Walker Todd testimony down here in North Carolina. And that Memphis Bank Trust versus Gardner out of Memphis, Tennessee. The evidence is overwhelming on our side of the fence. It poses a political question before this court. It poses what is known as the chaos doctrine before this court. But we are not the national security risk. And they want to come out and say, well, you've just now became a national security risk because you've exposed us. No, sir. The court is the national security risk because they hidden it. And the Bar Association hidden it. They're the national security risk, not the people, not us. Sit back, give some thought here to what we're talking about, because, ladies and gentlemen, you got a whole new argument going into these courts. You got a whole new argument. And if you would file your paperwork in, then remember, the day you get stopped, you have paperwork that next day, and you address these issues. Don't wait till you walk into court. Get them in. Because I tell you what, I was supposed to be in court on the 23rd. My mail that I sent out hit court on the 22nd at 12:30. By 2:30, I was notified that my hearing was postponed until the 3rd of February. Within 2 hours of my paperwork hitting, they postponed my hearing. Had nothing to do with snow. Had nothing to do with rain or ice. Was it a coincidence that my paperwork hit and my hearing got postponed within 2 hours? Think about it. I posed a question that the prosecutor can't answer without hanging himself. It's been an hour. I don't want to go on much longer. I just want to sit down and, like I said, go back in. For those who just got on, go back and re-listen to the recording. Get back into the last several recordings because, ladies and gentlemen, the information that we're dumping out here is a whole new realm of fighting in these courtrooms. It's a whole new avenue to fight in these courtrooms. Something that we've never done that we need to start doing. We need to start challenging them and not need to start challenging the name. We need to start challenging that birth name. That's not us. That belongs to the state. I'm a party of interest, and I'm not a partner in it. Thank you. You guys have a good night.